We'll be starting with our next session very soon. A very good evening, everyone. The next session that we have is by MCIA on experts as arbitrators or arbitrators appointed expert. I would like to invite on stage the panelists for this session, Mr. Janak Dwarkadas, Senior Advocate, who will be moderating the session, Justice R.D. Dhanuka, former Chief Justice, High Court of Bombay, Mr. Hiroo Advani, Senior Partner at Bharucha and Partners, Mr. Montek Mayal, Partner, Practice Head, Asia and Middle East at Osborne Partners, Ms. Kirtan Prasad, Counsel at RPC, and Ms. Hannah Fry, Barrister at 39 Essex Chambers.
One short share, sure. I'm happy to ask the questions instead. So just place in there. Yes, sir. Are you absolutely okay? Yeah.
Start. Good evening, everybody. Thank you, MCIA, first of all, for inviting me to moderate this session. Thank you, ladies and gentlemen, for being here. I believe you've been here since 8:30 in the morning. I admire your patience. I hope we don't test it anymore and don't get some brickbats, but we'll try to make it as interesting as we can. And I've got a wonderful panel, very distinguished to my left. You have Justice R.D. Dhanuka, who has been a judge of the Bombay High Court for many years and retired as the Chief Justice of the Bombay High Court in 2023. Since then, he's never looked back. He has a flourishing arbitration practice. He's authored a book on arbitration. His knowledge of arbitration law is encyclopedic, and the speed at which he can deliver judgments would shame even a jet plane. I always admired his stenos for trying to keep pace with him. Then we have Mr. Hiroo Advani, who has had 50 years of experience in the legal profession, and he has had the distinction of participating in arbitrations all over the world, in ICC, SIAC, Zurich Chamber of Commerce, LCIA, Swedish Arbitration Association, and what have you. So I move on to Mr. Montek, who has been an expert and who has set up FTI Consulting across the globe, which operates all over, and even has an Indian chapter. And they provide expert evidence in matters where expert evidence is required. And he has himself testified before numerous tribunals and rendered expert testimony. Then we have Kirtan. She is an experienced commercial and financial disputes lawyer, and she too has had a varied experience of having appeared before various international institutionalized arbitration centers like LCIA, ICC, SIAC, SCMA, DIAC, ICSID, and etc. And last but not the least, we have Hannah, who belongs to 39 Essex Chambers, and she introduced herself to me as being a colleague of one of my ex-interns, Karishma Vora, and who unfortunately is not here today. But Hannah has herself specialized in domestic and international practice, in commercial company law, and she has also appeared in the Supreme Court and the High Court, and again, like Kirtan, has had a wide experience of appearing in international commercial arbitrations in all the institutions that I have referred to earlier. So I think we have a very distinguished panel, unlike the moderator, who will be struggling to ask questions, and I hope to be enlightened by the distinguished members to my left. Before I get to the topic of the day and pose my questions, let me, for those who, like me, who didn't know much about this topic of arbitrators appointing experts and experts acting as arbitrators, let me nevertheless make an attempt, a modest attempt, to tell you what I think we should know before the questions are posed. Many of you, of course, must be very familiar, but nevertheless, it's my duty to point out that on account of rise in international trade all over the world today, disputes of very highly complex technical nature have become the order of the day and often go to different tribunals and institutions by way of arbitration. The American lawyers have called this a war, and they think that today's adversarial process is almost to be fought on a war footing. But that does not mean that it cannot be a civilized war and it cannot be elucidating. And that's where, if you ask me, very often the views and opinions of experts often help to decide very complex cases which arise out of parties from different jurisdictions who may be governed by different jurisdictions, different laws, and therefore have to battle with so many questions which arise. In India, the power given to the arbitrators, or the discretion given to the arbitrators to call for expert testimony, is found in Section 26 of the Indian Arbitration Act. I was quite surprised to find that this section is very similar to several such sections which exist in laws of other countries, including the rules which are framed by LCAI, ICC, and IBA, and whatever. So it's in a sense, it's probably nothing new, but nevertheless, it confers a discretion. What is interesting about Section 26 of the Indian Arbitration Act is it opens with what I would call words which are non-obstante in character, because it says unless otherwise agreed between the parties, which would indicate that it's a derogable provision. So it's open to the parties to say, we will not allow the arbitrator to call for expert testimony if the parties so agree. But in the absence of an agreement between the parties, the arbitrator or arbitrators of the panel would have full discretion to summon expert evidence where required. And when such an expert evidence is called for, obviously, the Act then provides that the arbitrators can require a party to make available to the expert any documents or any property or any goods which are involved in the matter. And then, of course, you have the provision in the section itself, which then again is based on a non-derogable provision which says unless parties otherwise agree, the expert himself can be called upon to submit to the parties and to the tribunal the basis on which he or she has rendered the opinion, which is the subject matter, and which is on a specific issue which the arbitrators may require expert testimony on. So that's basically what 26 is all about. Incidentally, I may also mention that in a sense, Section 26, whereas it authorizes or empowers the arbitral tribunal to call for expert testimony, the law with regard to expert testimony is of course found in Section 45 of the Indian Evidence Act of 1872, which is now 39(1) of the unpronounceable 2023 Act. And so it is in pari materia. So it basically, what it tells us is that expert testimony can be with regard to foreign law or science or art or identification of handwriting or finger impression. But what is more interesting is the fact that judicial pronouncements have told us that ultimately expert testimony is only a matter of opinion. And therefore both courts as well as arbitral tribunals have the discretion either to accept or reject the entirety of the expert testimony and rely on the evidence let in by the parties or otherwise. Now there are today's question is actually in two parts. One is the appointment of an expert by the tribunal. As I indicated, that is governed by, at least as far as the Indian Arbitration Act is concerned, by 26. And as I said, in other jurisdictions, similar provisions exist. The purpose of the arbitral tribunal appointing experts is obviously to get assistance on any specific issue which arises for consideration. But it may also help the tribunal to reconcile different approaches which may have been appointed, which may have come about by reason of party-appointed experts. So it may bring about, in that sense, a balance. The other advantage of the experts being appointed by the tribunal would be that, not advantage, but I would say when the arbitral tribunal calls for expert testimony, the tribunal must be careful to ensure that it does not delegate its decision-making process or function to the expert. On the other hand, we have a situation where the arbitrator who is appointed may himself or herself be an expert. Now, very often it happens that, you may find it in matters of, say, like the cotton exchange used to have in Bombay, disputes with regard to cotton trade going to experts, where they could themselves, in that sense, use their expertise for the purpose of bringing about a resolution. It could also arise where the party appoints an expert because the person is so well versed in the subject, like you have stock exchange arbitrations where the arbitrators themselves are stockbrokers and people experienced in the trade. The New Zealand High Court has laid down some words of caution. I'm not going to trouble you with all of them. My friends here will probably tell you more about it. But I may just touch upon them, that when the expert is an arbitrator, the arbitrator himself is an expert, and if he is going to rely on any documentary or other evidence, he has to share it with the parties in order to comply with the principles of natural justice, and he should not, in other words, gather any evidence behind the back of the party. At the same time, if what he is aware of is a matter which is generally known or generally the practice which is available and to the trade or otherwise, obviously he can utilize that knowledge, and that would not be considered a violation of the principles of natural justice. So with this background, I would like to move on to the topic for the day, and I would request Justice Dhanuka, who has had much more experience than all of us in dealing with arbitration and matters pertaining to arbitration, to help us answer the questions which we have. I propose to ask 2 questions, if time permits, to each of the panelists. So my request would be that since time is short, I know I've taken up a lot of your time, but if you can keep your answers brief and to the point, it will help us navigate the evening better. My first question to Justice Dhanuka is that when we talk about tribunal-appointed experts, why do you say this is different from the practice of party-appointed experts?
Before I answer this question, I want to tell you the distinction between a sitting judge and a retired judge. So for 11 years, I was asking question to Mr. Dwarkadas. And now after my retirement, he is asking me question. This is the change of position.
I cannot tell you what a pleasure it is.
I know that. So coming back to the topic, what is the difference? Party-appointed experts, it is their option whether to appoint an expert to assist them. Experts can be appointed even at the stage of drafting of agreement, because there may be different types of agreements. There may be construction contract, there may be partnership dispute, there may be relating to valuation of property, you are dealing in estate. And from that stage, and also at the stage of drafting the pleadings before the arbitrator, experts' assistance are taken by the parties most of the time. Not only that, when the matter goes to arbitration, I have seen, because I was appearing for municipal corporation for last 15 years before my elevation. And in all construction contracts, our engineers were assisting me, because I was not supposed to be familiar with the drawings, designs, extra items, and whatnot. So I was assisted by engineers. Sometimes it was happening that arbitrator is either engineer or is from legal fraternity. He is from engineering faculty, then there is no problem. I will assist him with the assistance of my engineer expert. As far as court-appointed, arbitrator-appointed expert is concerned, as my brother Dwarkadas has already told you about section 26, unless there is a prohibition under the contract between the parties, or that prohibition they agree at the stage of entering into the arbitration agreement, that we don't want any expert. Only in that event, arbitrator is precluded from appointing an expert. Otherwise, arbitrator has power to appoint an expert on a specific issue. Now take for example, arbitrator is a retired judge like me. Most of the time you will find there are allegations of forgery of signature. So what do? There may be some questions. Can a person from legal fraternity throw some light or render any finding whether the signature is forged or not? So handwriting expert is examined. It may be that parties may not examine any handwriting expert. Then what do? Then you take the task upon yourself and appoint an handwriting expert with a specific issue. Of course, once this arbitrator appoints an expert, there are parameters prescribed under section 26 itself. And those parameters, according to that, specific reference is made to the expert that on this point you have to render your assistance, you have to give your opinion to the arbitral tribunal for consideration. And then at the same time, parties are directed to assist the expert to give all data as material If he has to visit some property, he has to be permitted to visit the property, and then he gives an opinion. Once he gives an opinion, on the basis of that opinion, he can be called upon by the arbitral tribunal to remain present before the tribunal, and he can direct the parties also to remain present. Parties will be given the documents and details on the basis of which report is rendered by the expert, and before the arbitrator, parties can ask questions to the expert appointed by the arbitrator. Now, there is some gray area I must share with you at this stage, that questioning an expert before the arbitral tribunal, does it amount to cross-examining the expert? Or this is only to find out on what basis he has come to a particular opinion? If it is only for asking questions and he replies, at the end of the day, what is the evidentiary value of such expert opinion? Whether it is binding on the arbitrator, whether it is binding on the parties or not, that is again a gray area. Arbitrator is seeking assistance for his own benefit to come to a particular conclusion on which he himself has no expertise. In that event, he may rely upon that opinion, he may not rely upon, because parties are not precluded from raising an independent, taking evidence of an independent witness. They can examine still their own witness. So this is the difference between the two.
Thank you, Justice Dhanuka. Turning to Mr. Advani, since you had such a wide and varied experience having appeared in arbitrations across the globe, I would like to jump to the second part of the topic today. In your opinion, do you think that experts should be appointed as arbitrators? You think is there some advantage or not an advantage?
Let me start off by saying that I've dealt with a lot of experts and I have a high regard for several of them who've done an absolutely excellent job as expert witnesses. And the advantage of having an expert witness is you have expert witnesses on both sides. So you have the advantage of having two experts with contradictory views so that they can be examined closely and assist the tribunal in coming to the correct decision, whether to accept one expert, whether to accept the other expert view, or to accept none of them and come to their own decision. They have the rights. Experts as arbitrators, I'm completely negative to. The reason is that why are the experts there? Because there's a particular issue, and this gentleman who has been selected as an arbitrator has experience in that particular issue, and he's an expert in that. And frankly, my own view is that sitting as an arbitrator, he thinks he knows more than everybody else in any case. He's probably right. He might well know more than any else, but he will tend to rely more on his opinion than on any other experts or what the other arbitrators feel, because that's what he is. He's an expert in the subject. So he has confidence in his own views. On a second note, and a note that is very pressing right now in the Supreme Court of India, the government of India for some time has been trying to press having a panel of experts. So each PSU will have a panel of 5 or 6 experts and say to the parties, all right, you appoint one from that panel, I'll appoint one, the two will appoint one more, all 5 will be from the same panel. The government has been pushing this idea very, very hard. And why are they pushing it? And who are those experts they're using? All retired government servants from different other PSUs. So they're pushing this concept of a panel and trying to thrust what should be autonomy of parties. Each one should have a right to do what you think is best, choose who you think is the best. But they're trying to force this panel on. I heard the matter before the Supreme Court was going on for some time. I hope they strike that down quite strongly, because experience shows that the retired government servants who are appointed part of the panel are very, very pro-government, and you're highly unlikely to get a fair decision. So I think that idea should be struck down. I hope the Supreme Court does, but we're going to have to wait and watch. Personally, for these two reasons, I'm not in favor of appointing experts as arbitrators, but I'm very much in favor of using experts, and I think very highly of them. Thank you.
Thank you so much.
About experts being appointed as arbitrator, I agree with Sri Advani. I want to share with you on my experience. I'll just take half a minute only. I was appearing for municipal corporation in some heavy construction contract matter. And there was a clause that XYZ, not from the legal fraternity, will be arbitrator. And my opponent was on techno-legal. So I had raised a plea of limitation before the fraternity arbitrator, not from the legal fraternity, some other fraternity. I won't tell you the fraternity. So I cited one judgment of Justice D.K. Deshmukh before him. It was on issue of limitation. So my techno-legal opponent, he raised strong objection to me citing that judgment of Justice Deshmukh. He said that this judgment is not applicable, you can't rely upon this. It is not binding on the arbitrator. I said, why it is not binding? This is High Court judgment. He says, first of all, Justice Deshmukh has mentioned in the judgment 3 times that in his opinion it is like this. So he says, opinion cannot be binding on anybody. And second objection, I said, what is second objection? He said, second objection is that this is not award of an arbitrator, it is order of court, so court order does not apply to arbitration. So I told the arbitrator, told me, yes, he's right, what do you say? I said, please accept his argument. And after 10 years, that judgment award is just recently set aside by one of our High Court judgment.
Thank you. Thank you. Yeah, I'm just going to turn to you, in fact, Montek. You can add something and then I'll ask you my question.
I feel like I must defend the experts here a little bit. I also must say the panel just shot down my second career choice, so I can't be an arbitrator anymore. I think there's a bit of truth in all of that, obviously, but I also feel there are 2 points here. One is not every matter will require an expert as an arbitrator. Certain matters will benefit from it. Construction is a classic example, which I don't personally do, but I know a lot of the issues often relate to delays. There having a technical expert, I think, can add value to the decision-making process. Sometimes the questions are straightforwardly, in like oppression cases or similar type of cases, evaluation of shares. Again, I would imagine the tribunal might benefit from having an expert who understands those concepts deeply. So I think the point is, can all cases absorb an expert as an arbitrator? The answer is clearly no. I think some matters might benefit from it.
May I add to that, if you don't mind?
Please, of course.
I think what Montek is saying is I would agree with him because the appointment of an arbitrator is part of the autonomy of the alternative dispute resolution process. So one would have to take it that both parties, when they choose a particular arbitrator who may be an expert, would be doing so with full knowledge of the fact that if there are legal issues which require a legal expert or which are mixed issues of fact and law, then they probably would not choose an expert as an arbitrator. I think that's what you're...
Yes, yeah, precisely. And I think if it's a 3-member tribunal, yes, the chair should not be an expert probably. Right. I think that just a second point, which I think Justice Dhanuka just touched upon, I think there's also a question about the right form of training for an expert as an arbitrator. You have courses from CRB, etc., which help people like us who don't have necessarily the legal background to get the requisite training to sit as arbitrators. So I think the combination of two would often mean that there will be cases where I do believe an expert could be helpful to the decision-making process.
So the question I had for you, Montek, in fact, was that what, according to you, would be the circumstances which would justify an arbitral tribunal exercising its own discretion, like under Section 26, to call for expert evidence? What would you say? What are the circumstances that you think would justify it?
Yes, thank you. And I think that, so the Section 26 sort of, partly mirrors, or MCI Rule 28 partly mirrors Section 26. So I must first confess, I've only seen in very limited circumstances where tribunals have exercised this power to appoint their own expert. In 15, 16 odd years now, I've perhaps seen it 4 or 5 times, personally. I think there's sort of two, from my perspective, two circumstances where tribunals might benefit from appointing their own expert. One obviously is clear-cut when the parties themselves have not appointed experts, and there are technical issues that must be dealt with, and the tribunal might benefit from having their own expert look at those issues. The second, I think you mentioned in your opening remarks, is the conflict. Now, that's perhaps a beast of party-appointed experts. One of the biggest criticisms, as we know, is we are often labeled as hired guns. I don't think that's necessarily always true. There are some bad apples, there always are. I think most of us who do this for a living don't want to have a reputation of a hired gun because we won't be hired again, frankly. If you can't convince the tribunal of our analysis, we have no use to the parties and the council. So I think when there are large differences, like you said, to help reconcile those differences, a tribunal-appointed expert could be quite beneficial. The third I would say is, I guess it's a mix of the two, when the issues themselves are beyond the expertise of the tribunal itself, and they might benefit from just a third party providing those inputs. So I think those are the circumstances that I have seen, but I've rarely seen a tribunal-appointed expert in a circumstance where parties already have experts. I think one of the biggest pushbacks to tribunal-appointed experts is that they add to costs. So while I appreciate one of the main reasons for using tribunal-appointed experts is the concept that it makes the process more efficient, but I think that's just wrong. Because in that circumstance, you'll have parties in any case have their own experts, like shadow experts or dirty experts, as they're often called. And it only adds to the cost, actually. It doesn't reduce it. So I think I would say in the major circumstance where you do see tribunal-appointed expert is when there's no other expert involved in the matter.
Thank you. Thank you.
Just add one moment to that. You will find by experience again, when there's no party-appointed experts, and the tribunal feels like they should have an expert, they're more or less passing on the decision-making power to the expert rather than the arbitrator, and that happens far too often by way of experience.
All that you have to do is wait 10 years for it to be set aside.
So just one thing on that. I think that's a very important point. One of the major pushbacks for tribunal-appointed experts is that very issue, is the tribunal outsourcing its decision-making to somebody else. And I think that's where also the fact that regardless of a tribunal appointing the expert, the fact that that person should be challenged, should be cross-examined, is quite critical to the process. It can't be just accepted on face value, and I think there must be a due process given to the evidence submitted by the tribunal-appointed expert.
Thank you. Turning to Kirtan now, in your experience, I'm asking a very generalized question, but if you could educate the audience and all the panelists here, what are the cases where you think, what kind of cases do you think, I think some of them have already been touched upon, but what kind of cases do you think would deserve experts serving as arbitrators? And how should the parties go about choosing the expert, because they have the freedom to choose?
I think the slight risk of sitting on an illustrious panel like this is that quite often you've got nothing left to add after everyone has said. And certainly when you sit beside someone who's so impassioned about the cause like Montek, he sort of says most of what it is to say. I mean, needless to say, the sort of disputes that are best suited for experts sitting as arbitrators are disputes which require a huge amount of technical expertise. I think Janak very correctly mentioned, there are trade bodies like stock exchange boards, there's construction, which Montek has already raised, then there's commodities and trade. I mean, as perhaps standing up for the experts ever so slightly, I think we have an element of audience bias here, because the disputes that we as lawyers tend to receive or see inevitably tend to have a legal element. And so, rightly so, for the vast majority of disputes that come across our desks, experts aren't appropriate. But for extremely technical ones, perhaps there still is a case for them. The one case in which I had an expert sit as arbitrator was a GAFTA dispute, which again is, a trade body, very small set of rules, documents only process. I mean, it may be a facet of the GAFTA rules, but equally, I think there was something to be said for the expert or the layperson arbitrator, as we lawyers like to say, cutting through a lot of the noise in terms of the procedural rules. It was very much rounds of submissions from each parties, let me hear them, this is the decision. There was no over-lawyering of the process. So perhaps, and in fact not perhaps, I'm pretty sure that there is room for experts in a very narrow set of disputes. Another interesting set of disputes where I think there is room for experts, in addition to what Montek already explained, is we're now seeing parties enter into very complex financial arrangements and derivatives. Quite often, the dispute is not about how you construe the contract in those sorts of disputes. It's about how whether the termination price was valued correctly, effectively. And in those cases, you benefit massively from an expert sitting as the arbitrator, because quite often in those matters, the lawyers have very little additional legal expertise to add, if you will. And the second part of the question was really, how do you select an expert to sit as arbitrator? In some respects, not very differently to how you would select an expert to be your expert, in the arbitration. You would obviously look at technical expertise. You would look to see if the individual has the relevant expertise in that particular technical area. But one additional facet is assessing if the individual is capable of explaining matters in simple, clear, legal English language. Several courts, the Singapore courts in particular in recent times, have come up with quite a few quite a few judgments rather, criticizing the comprehensibility of arbitral awards. And I think with a lay witness or with an expert sitting as arbitrator, there's ever so slightly the risk that, if the subject matter is very technical, the award runs the risk of becoming or appearing to be even more incomprehensible when it's drafted. So it's important to speak to the expert that you are choosing to appoint as arbitrator, and to see if they are capable of explaining the matter in a way that lay people can understand. And the other aspect, it's not so much experience, but I think it's also to look to see what sort of academic writing the expert has been publishing. Because with experts, there is the risk of having, prejudged an issue really coming out as a result of their academic writing. So I think that requires a lot more scrutiny than you would in the case of an arbitrator.
If I could add to what you're saying, on the comprehensive ability to comprehend what the expert arbitrator is saying, I can share a personal experience where not that the arbitrator was an expert, but I had to gather some expert evidence in connection with a patent case, infringement of patent. And what I found very often was that the experts who we were interviewing and whose evidence we wanted to place before the court got so technical and got so carried away with the subject that we had to keep cautioning them and saying that, look, the judge is not an expert. You may be. So you better, dumb it down, as you say, and bring it to the level where it can be understood. So would you think, given that position, do you think the expert arbitrator could outsource this part of the job, the part which requires him to render an award which is easily understood?
I suppose the question is, who is your ultimate target audience for the award, or who is the ultimate reader of the award?
Keeping in mind that it will go ultimately, one party or the other might challenge it and would be read by judges who are not experts.
I think that's
a hypothetical case.
I think that's exactly right, which is, I think the ultimate target audience for the award is not even the parties. It is the judge who is going to hear the challenge. And with that in mind, I think barring trade cases like GAFTA cases or very technical construction contracts where quite often the parties have such a long-term relationship that they choose not to be as acrimonious and challenge every award. For the vast majority of larger commercial disputes that come across our desks, I think you're probably better off just appointing someone who mirrors what the judge is going to be like, i.e. a lawyer as the arbitrator, and then having two experts fight it out as between themselves.
Thank you. Now turning to Hannah, who's been waiting very patiently, and I apologize. arbitrations.
Thank you, and thank you MCIA for having me on the panel today. I'll start by saying that I often find that my job as counsel is translator between the expert and the arbitrator, so it very much aligns with what's been said today. I think generally the current state of play of arbitration is that expert evidence has now become the norm. There's such an increased use of it. And that aligns with the more technical and high value nature of arbitrations that we're seeing. In particular, I specialize in commercial and construction arbitration. And I'm currently involved in a case where we have 5 different disciplines of experts, including delay, quantum, and 3 different types of technical experts, which just goes to show the increased use of experts, in my opinion, in international arbitration. And I was looking at the statistics of this, and there was a BCLP 2021 International Arbitration Survey on expert evidence. And 96% of the respondents believed that they had a right to party-nominated experts, which just goes to show that this is very much becoming the norm. In terms of what I have seen and what I think is more effective, I agree with Montek that generally I have seen party-appointed experts, and it's only in a handful of cases that I've seen the tribunal-appointed experts. And I think often that is because in the Commonwealth, and particularly the English system, is that often experts are party-nominated. And that, or at least the parties believe that that means that they have more control over their experts, and therefore they can put their case forward more efficiently. I think where there may be perhaps more room for tribunal-appointed experts is, as we were saying, in cases where there aren't party-appointed experts, perhaps they're lower value. And in that type of case, I think there could be more of a room to appoint tribunal-appointed experts in order to keep costs down. Or if there's a concern about independence for any particular reason, again, that may be a place for a tribunal-appointed expert. I think a concern that was echoed earlier is that perhaps that gives more room for the tribunal to delegate their decision-making function. And generally, my concern would be that it would be more susceptible, the award, to challenge by the parties in that case. So that's something I think to be wary of. A general trend that I have seen is experts being used earlier in the arbitration process rather than later on. So recently I was drafting procedural order number 1, and in terms of tracks, we had the pleading track, and then we had a separate expert track. So experts were already being assigned different roles and encouraged to engage in discussion at the same time as the statement of claim. And various research and papers have shown that this leads to encouraged earlier settlement. So I'm definitely seeing a trend of more experts and being used earlier in the process, albeit perhaps not sitting as tribunal members.
Thank you, Hannah. Coming to my second question, Justice Dhanuka, do you think the system of parties appointing experts has really worked, or you think because it's only a matter of opinion, which the tribunal ultimately has the discretion to completely jettison and render an award on their own understanding, or based on the evidence let in by the parties minus the expert evidence? What is your experience? Has it really worked? Does it really help?
Parties can seek assistance of some expert to assist himself. That expert opinion is available to the party, not for the assistance of the arbitrator. But sometimes it is seen that arbitrator also may be guided by the, say, engineer or chartered accountant present in the arbitral forum. And he can guide the arbitrator, but it is not binding. It is for the arbitrator to decide whether to take assistance of the expert appointed by a party to assist him. Otherwise, arbitrator can himself appoint, but it is again a matter of cost. Because even if a party appoints an expert, at the end of the day, he is going to claim the cost incurred by him to appoint his expert as cost of arbitration. And in addition to that, if arbitrator appoints expert again, then there will be double jeopardy, because that will be again to be shared by both the parties. So it depends. If parties have already appointed an expert, I personally feel that arbitrator should not again appoint an expert, otherwise it will multiply the cost. Because I have seen that our judges or other arbitrators from legal fraternity, they are able to write good judgments with the assistance of experts. It's no difficulty. There may be evidence, there may be cross-examination, and even handwriting expert or suppose medical issue is there. So advocates prepare overnight with the assistance of some other expert to cross-examine such witnesses. Therefore, if once expert is appointed by a party, arbitrator himself should not appoint again, otherwise it will multiply unnecessarily.
Thank you. Hiroo, you mentioned earlier that you are not in favor of experts acting as arbitrators. But what do you think, how far should a tribunal go, in your opinion, to direct the work of an expert, since he's not the expert himself? How much can he, in fact, participate in that? And if he feels that he needs assistance, for instance, and he's not getting it, can he then direct the expert to render assistance? And if so, how far can he go?
Let me start, take one step backwards. More or less now in international arbitrations, it's almost become a rule that each party will have their own expert. Whether you like it or not, it's very likely to happen. And how do they actually function? Most sensible tribunals will tell two of the experts, first you two experts sit together, look at each other's reports, tell us which points you agree with each other and where you disagree. So you can eliminate a lot of cross-examination by, you'll find, a lot of the experts agreeing to a very large part of each other's, but coming to different conclusions. So you narrow the difference down. So in almost every international arbitration now, expert evidence has become a matter of rule, or as a matter of cost, should I say. Very, very seldom, unless it's a very straightforward arbitration, you'll find you're doing without experts. And then as arbitrators, you can actually play quite a role, because the differences are now narrowed down. You understood what the problems are, and the arbitrators ask quite a lot of questions of both the experts to try and come up with what they think is the right answer. And you're finding more and more arbitrators, in fact, taking a very, very activist role, not leaving the cross-examination only to counsel, but asking questions that are bothering them. And frankly, in those circumstances where the arbitrators have read the papers well, have understood, you're finding the best quality awards, in my experience.
So you don't think it amounts to entering the arena? That the arbitrator has entered the arena, because the judgments say that he should be dispassionate and keep his distance, and you don't think that's a problem?
No, I think it is important for the arbitrators to play an extremely active role and get to the bottom of the answers that they think are the right answers, then sit together amongst themselves, discuss the experts' views, etc., and then come up with the conclusion. And I think that's what happens in most international arbitrations today, and that's why some of the quality of the awards are absolutely first rate. Yeah.
Thank you, thank you. So Montek, coming back to you, what Hiroo mentioned about experts sitting together and trying to iron out the differences, you're more than familiar with the expression hot tubbing. So would you, for the benefit of the audience here, describe what hot tubbing means? Please don't get carried away, young guys, and educate us about what your views about this form of expert evidence, whether it helps or doesn't help.
Yes, I think the less controversial word is witness conferencing. Just before I answer that, I just want to say one thing, because you asked a question about, does the system work? I think it does. There are a bunch of us who do this for a living, so it's working. I think just the one point, which is I have seen the change in my 15 years of working in this, is there's a general self-regulation of the work we do, partly because, like I said, if you can't convince the tribunal, our evidence is useless. And the second is, I think increasingly we're finding tribunals being quite considerate / also careful in how they describe our work in the awards. And there's, the last thing we want is an award that tells how bad we were. And I think that obviously affects repeat appointments. So I think the mechanism of that self-regulation is making the system work. Now, to your actual question, what is hot tubbing or witness conferencing? In normal language, it's the experts giving evidence at the same time, right? They sit together and they're answering the same question one after the other. I'm a big fan.
Sorry to
Yeah.
break your thought process, but just as I've understood it, hot tubbing really means that the experts will sit across from each other and virtually have a dialogue with each other. They will question each other's answers and wisdom, and it will not be, there will be no interference in that sense from the parties. In other words, there'll be no cross-questioning or cross-examination by the parties when the witnesses are engaged in this process. So the idea is that between the two experts, they will try to narrow down what are the issues and what is the area on which they either agree or they don't agree. Am I right?
It depends. Lawyer's answer. I think it's not very regulated.
Okay.
There are many forms of hot tubbing. The most natural one that I have seen is slightly different than that, where we're sitting next to each other, but the tribunal will lead the conversation.
Okay.
So the tribunal sort of, let's say, identified 6 issues they want to discuss. They'll put those questions to one of the 2 experts. The other expert gets a chance to respond. Often, it's then followed up with the counsel asking questions as well, following from that issue. That's one way. I've seen what you have said before, what you just said before as well. That's, in my personal experience, more rare. It's more sort of tribunal-led, followed by question by counsel. But the idea is, the intention is exactly what you said. The intention is to discuss the issues in a conversation. It's supposed to be civil. Sometimes it is not. But it's meant to be civil, to have a conversation about these issues.
You mean they won't come to blows?
It gets worse than that. It gets much worse than that. But I think the intention is to narrow down the issues. And I think just before you get there, the reason you can do that is, and it's something Hiroo mentioned, before that, you've had, hopefully, what we call a joint expert report. So you've tried to list out the areas of agreement and disagreement. And therefore, the disagreement areas are very clear. And therefore, the cross-examination or hot tubbing is very clear and very focused on the disagreements. And that makes for an easier hot tubbing process, because the tribunal then knows which assumptions are really turning the needle here, which assumptions are really material to the outcome. And it presupposes the tribunal being very well prepared, and that's debatable. But if the tribunal is very well prepared, the issues are well set out, then the idea is you sort of ask those issues, those questions in turn to the 2 experts.
Thank you. Montek, we're running out of time, so now I have one question left, which I'm going to put to both Kirtan and thereafter to Hannah. And I want your independent, respective views. What do you all think about use of generative AI in place of expert evidence?
Thank you. Before that, could I just make one pitch? I think Montek's presented a very rose-tinted view of the process of joint expert reports and hot tubbing. I mean, there are processes where I've seen joint expert reports where people just regurgitate chunks of whatever's already been written in the expert reports, to the joint expert report turning into a 300-page document where you may as well get the parties to do an extra bit. Hot tubbing can actually be slightly better at narrowing the issues in dispute, particularly if you've got a switched-on tribunal, because there's an element of control over the process. You can wheel the experts back in. So sorry for deviating from that. On AI, I think all of the experts that we use in today's day and age come with huge teams that sit behind them, that assist them in the process of doing their research, that assist them sometimes in drafting the first drafts of their reports, etc. So my personal view is, why not resort to generative AI for that first round of research and that first round of producing, at least the introductory sections of your expert opinion. provided, of course, that the expert himself or herself exercises independent judgment in much the same way that you would if you were supervising a junior, to review the material that is being presented before you.
And what happens if the generative AI goes into hallucination?
Well, as the lawyer who had the make-believe cases come up before the New York courts, I think that's where it's important.
That was I was referring to that.
I think that's where it's important that you exercise independent judgment. No different to these days. If you give a trainee a task to go off and then run and do research, you still need to double check and make sure that the cases haven't come out of ChatGPT and that they're legitimate law reports.
Thank you.
Hannah, what would you like to say?
Yes, just to add, I think, and a good way to summarise this session is what is the main role of the expert, and it is to assist the tribunal. And I think it is important to sort of come back to that. And in terms of joint statements, again, as I was saying, I've seen early involvement of experts from the beginning. And my experience is that they're being used early on, and you're having sort of joint statement 3 and 4 post-pleading. So I think actually seeing the increased use of joint statements can narrow down expert issues, which the case can often turn on, and give to earlier settlement rates. In terms of AI, I think it will be similar to how it's being used by counsel, in that it's a tool, not a replacement. And that's what we're going to see going forward. And I think it will often be used in the disclosure process of reviewing information to get to a finalised report. And hopefully in 5 years' time, we won't all be replaced by robots at the next session.
Thank you so much. Thank you, all of you, for being here. I think we've been successful in concluding the session on time. The organizers will be very happy to see our backs. Thank you very much. I don't know whether there's time for questions and answers, but that's for the organizers to. Okay, go ahead if anybody would like to ask.
In your experience in different jurisdictions,
Can you identify which of the panelists you're
the
asking?
lawyers and the former judges, in your experience in different jurisdictions, how often do you, experts as arbitrators, how often do awards by experts who are acting as arbitrators stand up to judicial scrutiny?
One example I already given when I was speaking. You see, what is happening is that if you are not having legal background, in that situation, now everything has to be argued before the arbitrator. And if a lawyer is appearing before an engineer arbitrator or some other arbitrator or expert without having legal background, issue of jurisdiction, arbitrability, existence of arbitration agreement, res judicata, whatnot, and then you have to evaluate evidence, you are going to commit some mistake. And such awards are liable to be set aside, either on the first instance or after 10 years, whatever time it takes.
Just a little different experience because I've been involved with SIAC and with now the Dubai International Arbitration Center. And there has been an intense debate within the committee whether we should have experts at all on our panel. And by and large, the answer has come that let's avoid experts on the arbitral panel as our panel so that the institution will not appoint an expert as a presiding arbitrator. If parties choose to do so, that is their choice. We're not going to stop it unless he's not seriously an expert in that particular field. We're not going to stop it. But it's thoroughly discouraged at an institutional level to appoint experts as an arbitrator.
One more question. We have time for one more question. Yes?
Thank you. James Nicholson, FTI Consulting. Closely adjacent to what the panel's been discussing is expert determination. And that's not something one sees, at least in the kind of valuation-oriented cases that I get involved with very often. Do parties and tribunals make enough use of expert determination? And I'll ask that to whoever grabs it first off the panel.
I've actually been seeing an increased use of expert determination, and particularly, I don't know if it's just present in the UK at the moment, but I've seen it on both construction-specific industry issues and also on points of law. And perhaps it's related to the increased cost and length of proceedings of arbitration. So I think often if you need an urgent resolution, expert determination can be extremely useful, and I'm seeing more and more of it. That's in both industry issues but also legal issues.
Even here, actually, so you're seeing a lot of that in valuation of shares on exit, and you're seeing a lot of that in M&A disputes that are relating to purchase price adjustments.
Sushil Shankar. Montek mentioned something about getting reappointed. So that got me thinking, when it comes to appointment of arbitrators, we have the IBA guidelines and things, and we have the orange list and the red list, and which is hard-coded into our statute also. In the Indian Arbitration Act. But when it comes to appointment of experts, although we have the CIR protocol and we also have the IBA guidelines on appointment of experts, but these are more of suggestions and there is no absolute bar on reappointing an expert, although they do mention that the expert should be neutral. So is it time to have something like this, like the way there is a bar on appointment of an arbitrator beyond a certain number of cases, the party appointing the same expert over and over again?
That bar is already there under 7th Schedule of Arbitration Act. How many matters one arbitrator can be appointed by the same party?
No, I meant the expert.
I think the question was whether there can be a cap on the number of matters in which he can give expert testimony.
Yes.
No, there is no such bar.
No, I know there isn't. I'm saying, isn't it time for something like that to ensure neutrality of the experts?
May I pitch in on that?
Yeah, sure.
I think most experts, in fact, all experts, do produce copies of their CV. And the system has an inherent check and balance on experts repeatedly appearing for the same party, which is that an arbitrator is going to give their evidence less weight. So unlike in the case of an arbitrator, I think there's an inherent check and balance in the system. Could we come up with a protocol on perhaps, but I think there's an inherent check and balance in the system, so it's not as necessary.
But that would vary from arbitrator to arbitrator.
Yeah, because it presupposes that even the arbitrators are common in the successive disputes. See, there are two parts to it. If the testimony of a particular expert has been accepted by a tribunal and has been found, in that sense, has been not been disturbed later on in the challenge which may have been mounted, then his credibility has been in fact established and his reputation would probably require that, and he's earned the reputation to be called as an expert once again. And there's nothing wrong, I personally feel, if the same party were to use his services again, giving the track record that he has established. I think I'd like to hear from Montek what he has to say on it.
I hope there's no bar. Sorry. But there is case law on this. I'm happy to pass to you. Some tribunals have looked at lack of disclosure on professional relationships of experts, lack of disclosure of previous work. Some codes also require you to disclose previous work. I think all firms, and I was part of a big firm before this, all firms have internal guidelines because they're very live to some of these issues. But for the reasons you said, I think it's very difficult to have a particular number, especially when, I guess it's even harder in markets like India, where the practice is less developed. So it might confine the use of experts if you put bars which are very narrowly defined.
Sorry, and also fundamentally, if the expert has been challenged and someone else has had the opportunity to question everything, then really is there a need for a party-appointed expert to be held to that level of independence and impartiality?
Yeah, that's also. Thank you. Sorry, Montek, nothing against you personally.
You did get him worried a bit.
I request you all to please remain seated. We'll be starting with our next session very soon. And we'll have the dinner and drinks after the session. Thank you.